to today's webinar, Doing Business Abroad, which is part of our series, Progressing with IP. My name is Fasiha, and I work in CIPO's Business Services branch in the Intellectual Property Awareness and Education team. Today, I'll explain the importance of protecting your IP in the countries where you plan to do business. This is a complex topic, and while I won't go into in-depth detail about it, you should have a pretty good understanding of the concept of protecting IP abroad and the important steps to consider during the process. Before we start, you might be wondering what CIPO does. IP rights are territorial and are managed by the IP offices of countries around the world. In Canada, it's us, the Canadian Intellectual Property Office, or CIPO, that is responsible for the administration of most Canadian IP rights. CIPO is part of the Government Department for Innovation, Science and Economic Development Canada. We handle application guidelines, forms, examinations, and more used in the process to issue patents, trademarks, and industrial designs. We also work on increasing IP awareness among Canadians. So as I mentioned, we work to raise awareness for the effective use of IP by Canadians. To this end, our IP awareness and education program delivers a wide range of products and services free of charge to help Canadians better understand the importance of protecting and maintaining their IP assets. We are a team of content writers, presenters, and IP advisors who can assist innovators, creators, and entrepreneurs in better understanding their IP before engaging in discussions with IP professionals, lawyers, or others where inevitably their IP will become a central point of the conversation. Therefore, we have the resources to explain what IP is, how we can help you identify your IP, how to protect your IP, how to manage your IP, and most importantly, where to find help. Our tools and resources are available on our website. We offer fact sheets, detailed guides, online learning modules, and roadmaps to explain the steps to register for formal IP rights. We also organize seminars and webinars, and it's also possible to arrange meetings with our IP advisors either online or in person. Over the next few minutes, I will answer the questions that you see on the screen and explain why you should protect your IP abroad and minimize IP disclosures before filing, how to check whether the IP already exists abroad and what's important to know about target countries, and finally, how to apply for IP rights outside of Canada. Let's begin with an overview of what intellectual property actually is. IP is all around us. It's in the clothes that we wear, the coffee that we have in the morning, the electronic devices that we use every day, and the music that we listen to on the way to work. IP can come from a creation of the mind. It's actually the form that an idea takes when created that can be protected. A few examples of intellectual property include inventions, symbols, logos, pictures, designs, literary and artistic works, and many other representations. IP rights encourage innovation by giving creators the exclusive right to prevent others from stealing or appropriating their innovation. We find that most businesses have some form of IP, whether it's formally protected or not. In business, IP can set one's goods or services apart from others and is referred to as property because just like real property, rights are acquired with ownership. Like when you own a building or land, you can sell it, lease it, and keep others from trespassing into your space. Similarly, with IP, you can sell it, license it, and exclude others from using it. Also, like real property, IP is a valuable business asset. Here on the screen, you see traditional types of IP and the registered rights that are associated with them. Let's begin by taking a look at trademarks. So trademarks are signs that distinguish one's products and services from those of others in the marketplace. A trademark can be a word, a symbol, a design, a taste, or even a sound or a scent. It's what consumers often first see and how they navigate the marketplace. It's really about being distinctive so that consumers can easily identify a trademark with the associated product or service. Trademarks also include geographical indications and certification marks. Now, patents apply to functionality. They provide technical solutions to a given problem. It's the way you can protect new or improve products, machines, processes, and compositions. In order to be patented, the invention must be new to the world, useful, meaning it must work, and inventive. Then there's also copyright, which typically protects music and artistic creations. Copyright is all about original expression and creations that use some level of judgment and skill and are not just a mere copy of another work. Then we have industrial designs, which concern the appearance of an object. They serve to protect the unique appearance of a product, not anything to do with its functionality. It's all about what appeals to the eye, unique shapes, patterns, etc. that can be found on clothing, fashion accessories, technological devices, and the list goes on. Lastly, there are plant breeders' rights, which protect varieties and denominations of new plants. However, CIPO does not manage these applications. Instead, it's the Canadian Food Inspection Agency that takes care of those. So IP includes valuable information, but it's also important to note that there exist other types of IP which hold valuable information, but that cannot be formally protected. A good example of this is a trade secret. This can be any business information that derives its value from its secrecy. It can be a method, a technique, any know-how, research, analysis, data, a customer list, a formula, a recipe, and so much more. It's some sort of competitive edge, but one that cannot be formally protected. Trade secrets can be incredibly valuable. However, they may not be the best choice of intellectual property protection if your competitors can easily reconstruct or reverse engineer your creation. Remember, reverse engineering is when you can recreate a product just by looking at it or seeing how it functions. There are, of course, other examples of non-traditional IP as well, things like domain names and websites which are not the same as trademarks. As well, social media accounts that actually contain a lot of IP, such as trademarks, copyrights, more, and of course there's publicity rights to consider as well. First off, why should you protect your IP in another country when considering business expansion? IP can be a company's most valuable asset, but when it's registered in Canada, it does not automatically give you worldwide protection. If you're looking to expand your business activities outside of Canada, it's important to protect your IP abroad so that you can 1. Strengthen your presence in key target markets. This allows you to establish your company's credibility and builds trust with international customers. Second, it allows you to maintain a competitive edge. Strong IP protection keeps you one step ahead of the competition. Your innovations and ideas are secured, giving you a valuable and sustainable edge. Then, it allows for international partnerships to develop. If you plan to collaborate with customers, manufacturers, or suppliers abroad, IP protection becomes crucial. This lays a solid foundation for successful business relationships. And lastly, it allows for growth opportunities. Early IP protection can open doors to new business opportunities, and it makes it easier to negotiate licenses, partnerships, and other future expansions. So start off with taking a close look at your IP assets and identify the best protection strategies for each specific market. You should consider acquiring rights in every country where you wish to obtain protection. Poor planning, misunderstanding, or unfamiliarity with IP rights can get you into serious trouble. Taking preventative measures from the onset can save you from potential problems in the future. We talk about IP protection abroad or in another country, but it can be so much more meaningful than just that. Today, the majority of products have a foreign component, so IP protection is indeed a global concern. So you need to protect your IP in the markets where you plan to discuss, exhibit, sell, or manufacture your product. When engaging in commercial discussions, ensure that sensitive information is protected by confidentiality agreements to avoid any risk of unauthorized disclosure. When it comes to exhibition, if you plan to present your products at exhibitions or fairs abroad, make sure that your IP is protected to prevent unauthorized use. And when it comes to sales, before marketing your products internationally, make sure you have IP protections in place to prevent counterfeiting or unauthorized use of your trademarks and designs. And when it comes to manufacturing, if you plan to outsource that abroad, make sure you protect your production methods, processes, and technologies. You should also consider protecting your IP in countries where you want to prevent others from copying, manufacturing, or importing your products. It's essential to bear in mind that IP rights are territorial, which means that protection must be specifically established in each country where you operate. An IP right obtained in one country limits protection to that country only. An official IP right can be essential to prevent low-end or counterfeit products from getting through customs. So remember that each country has its own set of IP laws and practices, so you must be sure to work with IP law professionals to put in place the appropriate protective measures in each jurisdiction. This will provide you with a solid foundation for international success and expansion. Now, when embarking on the process of protecting your intellectual property, caution is key. A common mistake is to reveal or disclose too much information about your IP too early, and this can have serious consequences for your business, like increasing the risk of imitation and counterfeiting, and may even prevent you from protecting it in certain countries. So it's crucial to minimize disclosures about your IP before filing your application, as well as other essential business information that you should keep secret. So of course, there are many different risks to consider if you don't minimize disclosure. For instance, someone could copy your idea in a foreign market. Or if you present your invention at a convention or a trade show, someone could steal your idea and potentially file IP rights for it. As well, disclosing information can prevent an inventor from obtaining a patent or registering for an industrial design. Their own disclosure may be considered prior art if it is in the public domain. And lastly, almost all countries have a first filed, first served patent system, rather than a first invented, first served system. So keeping in mind disclosure is absolutely crucial to protecting your innovations. And even if you can prove that you were the first to think of the invention, the race may be lost if a competitor files before you. Disclosures are often made accidentally, but sometimes they can be made intentionally. To avoid this, while you're trying to obtain official protection, make your inventions and other sensitive information trade secrets. Now, it's good to have trade secrets, but it's important to protect them both internally and externally to your company to maximize their value. Certain precautions can help you protect your IP as a trade secret and can also enable you to take advantage of certain protections subject to local trade secret laws. There are some precautions that you must consider when protecting your trade secrets. First, you should educate your employees and collaborators about IP and trade secrets. You should explain what information is confidential and how to share it in compliance with the non-disclosure agreements you have in place. As well, it's important to evaluate and define the minimum information that you can share. In this, be selective in the information that you share with the employees, partners, and third parties, and communicate only what is necessary. Next, you should restrict access to employees and external partners with confidentiality or non-disclosure agreements. As well, you should track access to confidential information. So a document tracking system can help investigate theft of trade secrets and show that protective measures have been taken. And lastly, you can evaluate the timing of the disclosure. So think about the location, the context, the people present, and the phase of IP development. And try to avoid bringing prototypes or sensitive objects to risky locations. In the end, communicate sensitive information only on a need-to-know basis. Protecting your trade secrets is an essential step to maintaining your competitive edge. Now, before applying in other countries, checking whether IP exists abroad is an essential step when considering doing business outside of Canada. The first thing you should consider is the importance of verification. So if somebody already owns IP in another country, this could limit or even prevent you from formally protecting your IP here in Canada and then taking your IP abroad. As well, you should consider, is someone else using your trademarks or similar ones? And if so, are they using the same classes of goods and services as you? Is your trademark likely to be too similar to something that already exists? Are these IP rights maintained? For example, have patent maintenance fees been paid? Has the trademark been renewed? These are all examples of questions you should ask yourself before taking steps to protect your IP abroad. Next, you should locate IP related to your creations. There are several free online databases where anyone can find and read patents, see trademarks, and industrial designs from around the world. The World Intellectual Property Organization, or WIPO, their global databases are a good place to start. I'd like to emphasize that this is only a first search. You should let an IP professional properly verify and complete your search. Exploring, finding, and understanding IP rights can be complex, and this step is absolutely crucial to ensure that your foreign expansion efforts are based on solid information. As well, when searching databases, there are important limitations that you should be aware of. You'll probably never be able to find everything yourself, even with the help of an expert, but there are still certain limits. For patents, you're going to be limited to publicly available data. The application becomes public 18 months after the filing date, and then patent information will be available in databases on various websites. Once the patent has been made public, due to the complexity of the applications, the technical vocabulary, and the different languages, it's virtually impossible to find all the relevant publications. For trademarks, you are limited to registered and pending trademarks. You won't find any unregistered trademarks. Also, in general, company names are not necessarily registered as trademarks. For example, if you intend to apply for trademark registration of your company name, it's advisable to check that there is not already a company with the same name. For industrial designs, you will not find designs in all countries. In some countries, data is not available, or no IP rights have been granted for designs. Copyright is automatically established when a work is created. Canada and over 176 other countries have signed the Berne Convention, which deals with the protection of works and the rights of their authors. There is no international system of copyright registration, nor are there any requirements for official registration. Most countries have a system in place to enable official copyright registration, but it's titles only that you'll find in the databases. For example, if you compose a song and you go into the CIPO database, you'll only be able to search for the song title. If you only remember the lyrics, you won't be able to find another work. And the same applies if you're in the visual arts, theater, photography, or even software development, and you're seeking copyright protection for them. You'll only be able to search the databases by title, so it's not always very easy to find what you're looking for. Now, in your opinion, is the following statement true or false? IP laws and regulations are the same across the world. False, of course. IP rights, as we know, are territorial. Each country has its own IP laws, regulations, and practices. It's important that you understand and respect the specifications of each jurisdiction for effective protection of your intellectual property. In doing your research, you'll find important details about getting IP rights in a target country, such as languages, fees, timeline, representation, and other IP right-specific considerations. For example, when considering a patent, you should ask yourself, what can I patent? Is there a grace period? Do they have utility models? Are they part of the PCT or the PPH? For a trademark, you might ask yourself, do I have to register? What is the use requirement? Are the PNS categories the same? Do they have the Madrid system? For industrial designs, you may ask yourself, again, is there a grace period? How long does protection last? Do I have to register? And are they part of the Hague system? And of course, for copyrights, you should ask yourself, is there any point when a registration is a requirement? All very important questions to consider. And to learn more about your target countries, you can consult our Doing Business Abroad guides, and you can find these on our website. In these guides, you'll find information about where to apply for registration of each type of IP right, information on how to enforce IP rights in your target country, and more advice on where to turn to for further help. So there are two main ways to apply for IP rights abroad. Method 1 is to file your application directly with the IP office of the target country where you wish to obtain protection. This method is often used by Canadian companies applying for IP rights in both Canada and the United States. For example, many companies start their patent applications in the US and then use this US application directly or shortly thereafter as the basis for a Canadian application. If the company feels that it needs to apply for IP rights in many other countries, it may be advantageous to use an international application system, which is the second method. So method 2, as mentioned, uses an international application system that allows inventors and creators to submit and pay for international applications through a single online portal. As Canada has signed international IP agreements or treaties, it is now easier for Canadians to apply for IP rights abroad. Much work has been done to standardize the application systems to enable inventors and creators to submit and pay for international applications through this famous online portal. Each country has its own set of IP laws. In the formal process of IP protection, these laws must be followed. In whichever method you choose, whether domestic or international, each country will examine and grant IP rights in accordance with its own IP laws. So using an international application system can save you time and money when filing for IP rights in several different countries, all within a single application. It's very convenient. If you apply for IP protection in more than one country, the total fees may be lower and easier to pay than if you were to apply directly in several different countries separately. An IP professional can advise you and give you an idea of these potential savings. There are other advantages as well to filing a single international application, such as the convenience of it all being in one place in a single language and for a single payment in a single currency. Once this application is received by the IP office of each target country, it will be examined in accordance with their IP laws and practices. It's important to note that an international application does not give you worldwide protection. Your IP rights will only be protected in the countries where you have applied for registration and where you will obtain registration. We recommend that you consult an IP professional to learn more about certain eligibility requirements when filing an international application. There are differences depending on the country in which you wish to obtain a registration, so it's really important to consult an expert. For example, in relation to patents, the international system has the advantage of giving you up to 18 months of extra time to pay application fees in the countries where you wish to obtain protection. This can be an interesting time to look for partners and funding to commercialize your invention. This international application is like a two-step process. The first is the filing of the application, and the second gives you valuable time before proceeding to payment. So now let's talk about what systems are available for international applications. For trademarks, you can file an international trademark application under the Madrid Protocol. The Madrid system can offer trademark protection in over 120 countries. For patents, the International Patent Application is filed under the terms of the Patent Cooperation Treaty, or the PCT, and protection can be sought in over 157 countries as of August 2023. For industrial designs, international registration can be carried out using the Hague system, and protection can be sought in over 90 countries. And for copyright, there is no international registration system. Copyright is automatically established when a work is created. In Canada and over 170 other countries, they have signed the Berne Convention, which deals with the protection of works and the rights of their authors. There is no international system for copyright registration, nor are there any requirements for official registration. However, voluntary registration of a work can make your job easier if you need to prove that you are the owner of a work in the event of a dispute. Most countries have a system in place to enable official copyright registration. Now, let's go over some frequently asked questions. So, how many countries must be added to an international application to make it worthwhile, rather than using the national systems of the countries chosen? For patents, they usually say 3 countries, but it depends on many other factors, such as the length of a patent, the country where you want to file, and more. Similarly, for trademarks, if you have many classes, it can make a difference. Only a precise analysis of the specific situation will be able to give you a better answer. So once IP rights have been obtained abroad, it's important to enforce them. How can you defend them? Well, IP rights are infringed when someone uses your IP without authorization. So if you own a registered trademark, patent, industrial design, or copyright, you are responsible for protecting your IP rights. CIPO grants IP rights but does not monitor the rights granted or the market, either here or abroad, for potential infringement, nor are IP organizations abroad responsible for this. Resolving disputes involving IP rights is often complex. It's advisable to consult an IP professional, such as an IP agent or an IP lawyer, before taking steps to enforce your rights. For example, if you own a patent for a technological innovation and discover that a foreign company is producing and selling your invention without your consent, this could constitute an infringement of your intellectual property rights. In such a case, you might consider taking legal action to defend your rights and stop this unauthorized use. However, this process can be complex and involves different laws in each country concerned. That's why it's essential to consult an intellectual property professional for advice and appropriate action. If you think someone is infringing your rights, consult an IP professional immediately. First, to check whether your IP rights are being infringed or not, then to assess the damage, and finally, to determine the appropriate course of action to enforce your rights. So as I mentioned throughout this presentation, it's crucial to hire an IP professional when seeking to protect your intellectual property abroad. Exploring, researching, and understanding IP rights can be a bit challenging. IP professionals can provide valuable assistance through their in-depth knowledge of IP regulations, procedures, and laws in the countries where you are considering doing business. They can guide you through the correct use of international application systems. These experts can advise you on what action to take if you believe that you are a victim of counterfeiting or if that someone has infringed upon your IP rights. And in some situations, your Canadian IP professional may work in collaboration with a local agent to act on your behalf before the IP office of the country in question. Before meeting an IP professional, good preparation is essential. Carry out your own preliminary research and ask the experts to verify and complete your research with the missing information. Research the markets that you are interested in to avoid conflicts related to third-party IP rights in those areas. Also, identify where your competitors and partners have filed for IP protection, as this may give you clues to their key markets. And finally, consult the Hiring an IP Professional fact sheet on the CIPO website to help you get started for more information. So all of the resources, materials, and tools that I've talked about contain a wealth of useful IP-related content and are available in many different formats such as audio, video, text, and interactive on the CIPO website. We are happy to guide you and give you as much information as possible on IP rights. However, we cannot provide you with legal advice. And unfortunately, all of the questions that you see on the screen right now are questions that require a legal opinion. You might also require help in understanding complex IP topics, obtaining legal advice in the case of infringement, or seeking an opinion on strategic positioning and searching advanced databases. And to that effect, there are groups and associations of IP professionals that you could turn to. To locate a licensed IP agent near you, you can contact the College of Patent and Trademark Agents, or CPATA, which is the newly formed organization responsible for the management of IP agents. We recommend that you only deal with IP agents that are on the CPATA list of registered IP agents, as those are individuals that have passed IP-related exams, they are regulated and disciplined by the CPATA. Unfortunately, there are individuals out there who will try and pose as an IP expert despite not having the required credentials, so it's imperative that you stay diligent and that you consult the CPATA website to ensure that you know who you are hiring to assist you with your IP rights. And lastly, the Intellectual Property Institute of Canada, or IPIC, and the Bar Association are professional associations where you can also find lawyers or other IP professionals. Please do not hesitate to contact us if you have any questions or need help finding any of the resources on our website. You can reach us via the contact information that you see on the screen. You can also contact our intellectual property advisors for a more specific and tailored discussion to your needs by scanning the QR code that you see. And for all general questions about IP, please feel free to reach out to our customer service center by phone or email. The toll-free number is also provided on the screen. I also invite you to follow us on our social media profiles, and I also recommend exploring the CIPO newsletter titled IP for Business News, where you can find more information about new IP products, seminars, webinars, upcoming events, and changes to the CIPO website. So, this concludes our webinar on protecting IP abroad. I hope you have learned more and have enjoyed this presentation. To learn more about the topics related to IP mentioned, I invite you to watch our other videos and register for our live webinars on our website. Thank you so much for watching.